Jankins to the studio with us once again, talking bankruptcy, and what we're going to do is pick up where we left off last time, because a lot of people were digging what you were saying you helped explain a lot of things when it comes to what happens in certain cases involving bankruptcy.
Okay, well, last time we started out by discussing how bankruptcy area of law intersects a whole bunch of other areas of law,
right.
And where we left off, we were talking about inheritances and how those can be impacted by bankruptcy. Well, another type of inheritance kind of that people get is life insurance. So mom or grandfather dies and all of a sudden somebody lucks into $100,000 or several $100,000. That can be impacted by bankruptcy as well. With the regular inheritances, we had talked about if somebody had become entitled to their inheritance within 6 months of their bankruptcy filing, it's too bad they lose the money and it gets used to pay their debts in the bankruptcy.
Mm-hmm.
Now, if there's a life insurance policy, it's not quite as harsh. So if it's a small policy, you get to keep it.
Okay, what do you consider small policy?
$15,000 and under.
Wow.
So
there are $15,000 life insurance policies?
There are.
That's the.
What if their life insurance was used towards bills that they had to pay and you get what's left? Or is that how does I don't even know how life insurance works?
A life insurance policy is contractual, so I mean a beneficiary is named, and whoever is named as the beneficiary, it's their money.
Oh, okay.
So it doesn't really go as part of the rest of the will or anything like that.
Okay.
It just goes to the person that's named in the policy, unless they happen to name their estate in the policy, which I'm not an estate attorney and I try to stay away from that stuff.
Right.
But sometimes people will do that for tax purposes and some planning devices. So, but yeah, if you're named on the life insurance and it happens within the 6 months, if it's $15,000 or under, you get to keep it. If it's $50,000, you get the first 15, and then the rest goes towards your debts. So again, we still have the same discussion with our client, you know, do you have anybody that might die? And we don't really ask it that way. We usually ask people, are you entitled to get any inheritance right now for someone that's already gone?
Yeah, I think you usually phrase it, is there anybody in your life that has one foot on a banana peel and the other, well...
kind of like that.
Yeah, okay.
And,
what if it happened before you filed bankruptcy? Is there a guideline in there? It's like, oh, you just got this 6 months ago and now you've filed bankruptcy, so...
Well, if it's a lot of money and you got it, you probably aren't going to be able to file the bankruptcy because you've got too much money that you probably can't get rid of in ways that we, bankruptcy planning, where we can move assets and money that isn't protected into protected things. Sometimes you can do that, but sometimes there's too much money and you just can't get rid of it all.
Okay.
And then the person just has to look at other options for their debts, like the novel thing like pay them or negotiate settlements with the creditors, so we do that sometimes. But yeah, it's kind of tricky, and I actually had a client once where it was that exact situation, and we suggested that they be changed as the beneficiary on the policy. It was an annuity type policy, and the person attempted to do so and mailed in a request for beneficiary changing, and as it so happened, the person that was kind of hanging on died. And when it turned out to get the money, the place that was supposed to have the change in beneficiary said, well, we never got the change.
No.
So my client had to give up the money, and it went to pay debts, so that was sort of disappointing.
Yeah.
There's no paper trail you can follow to...
Yeah, lost in the mail.
Lost in the mail.
The lesson is send it certified mail, or in this case, I think it happened to be principal. If it's me, I'm hand delivering it, but she didn't, and it kind of was a harsh lesson.
Right.
So that's kind of how probate, it's real murky, and that's kind of a lot of problems that can occur with probate. Now, another area of law that's real complicated as it relates to bankruptcy is divorce. And it's in two different ways. If somebody might be entitled to property settlement and divorce, it's kind of like inheritances. So if you become entitled to that property settlement within the 6 months before you file or after you file your bankruptcy, you forfeit that. You have to tell the bankruptcy court, hey, I got this property settlement in my divorce, and they'll say, okay, thank you very much, and you give it to the trustee of the bankruptcy and they pay your debts with it. Well, that really shouldn't happen. Number one, if someone's going through a divorce and they're also going through a bankruptcy, they should kind of tell their divorce lawyer, hey, I'm going through a bankruptcy, it might be important.
Right.
And
you would think.
And it's kind of this rule about the money coming into the bankruptcy. It's not something that's universally known that all lawyers, because their lawyers, know this. It's really kind of a very obscure provision of bankruptcy, and frankly, I don't think a lot of divorce lawyers even are aware of it. And I can assure you that there's many bankruptcy lawyers that aren't aware of it until it happens to them, and then they become painfully aware of that little provision. So there's got to be communication. If somebody's got more than one lawyer working on different cases, the lawyers need to communicate, and often we tell our clients, look, you better have your divorce lawyer call me, because there could be issues that come up that could affect what you're trying to do. Right. Sometimes they call and sometimes they don't.
Right.
This 180-day thing is really important. I had a case years ago where the divorce lawyer actually referred the person to me to do the bankruptcy, and then they get their divorce all settled and everything, and lo and behold, someone raises an issue saying that the person got a big property settlement and didn't report it in their bankruptcy. Well, as it turned out, the judge signed the divorce decree like 181 days after we filed the bankruptcy. So it's got to be 180 days and it comes back in. So that person lucked out. By a day. And so timing's really critical, and it shouldn't have been that close. I mean, nobody ever likes to have things that close. There was a lot of nervous people involved in the thing, and it was a significant amount of money, but the person turned out okay. But that just shows how critical this is. And you know, the divorce does not become final till the judge in the divorce signs the divorce decree, and then it's stamped in by the court. Then it's final. So it's just really important to make sure everyone's got, you know, on the same page. We tell our clients, you know, if you settle your divorce and get a property settlement, to, you know, within the 6 months, you got a problem. And so sometimes divorces take a long time anyway. Yeah. So you know, having it take a little bit longer is going to make that much difference. So it's just a good idea to make sure that everything's set up right. Now, on divorce, there's another component. If you're the person that's got to pay, and you file bankruptcy, it used to be before the changes in the law back in 2005 that those could go away in many circumstances, and you could walk away from the obligation. Well, the law has changed, and they put in language in the bankruptcy that says, well, no, if you've been told to do something in a divorce, you can't get out of it. But it's really murky in the bankruptcy rules, and it's not like just spelled out in one place. So trying to convince a divorce judge later on, he can't get out of that in the bankruptcy is not so easy, because the divorce judges and the state judges, they don't know lots about bankruptcy. It's federal law. It's not something that comes into their court. Right. And so it gets a little bit difficult. So if you're a person that's supposed to get some money and the person that's paying it is filing bankruptcy, you really should go see a bankruptcy lawyer to talk about, should I do something about this? Right. Because we always recommend to those people that come to me, even though you don't have to do it, we recommend that you come and file some stuff in the bankruptcy to get the judge in bankruptcy to make a legal determination that it's not going away. Because later on, the judge in state court might say, well, until we get an order from the judge in bankruptcy or something in bankruptcy that says, hey, I can enforce this divorce decree and hold you in contempt for not paying your obligation, I'm not going to mess around with it until I get an order from bankruptcy, because that's how they used to treat it. Right. And so we recommend, even though you don't have to do it, it's a slam dunk. All you got to do is go through the process, and you do have to spend some money with the lawyer, which is unfortunate for them, fortunate for me, and get your protection. And so you have it in black and white from the federal court. This isn't going away. Then the lawyer that represents the person in divorce court can say, Judge, here's the federal bankruptcy order. That guy or that gal's got to pay, and then they can deal with what they got to deal with. There you go.
Yeah, a lot of things to remember here, so it's good to have a lawyer to help you out.
Any questions on this? Where can we get a hold of you?
You can call me at 255-1855. I'm happy to talk to you on the phone. Otherwise, you can schedule an appointment with my secretary, and you can find us on the web at www.iowa-bankruptcylaw.com.
Perfect. Thank you, sir. Appreciate it.
Thank you.
It is 8 minutes before 9 o'clock. We'll be right back. You're watching Great Day.